Okay, good day. This is Dan Barrett from the Greater Toronto Area Council, and I'm here today on the 19th of August to talk to you folks about our Politics of Unions outreach and its best practice workshop. So today we had a chat with a couple of folks from some locals. So at today's meeting we were talking about some of the differences between the Treasury Board locals and some of the folks in agencies, and so we're going to be specifically discussing getting some feedback to the participants there related to how to deal with management on grievance type issues such as the Phoenix process. So the workshop, this workshop is entitled Unions and Management Where Synergy Meets Engagement, and so the intent here really is to look at the relationship between unions and management as a dialectic where management's position traditionally falls along the aspects within the workplace of leadership and implementation of policy, whereas the employees traditionally take the role of effectiveness. And the synergy between that relationship is really where you're going to have the best bang for your buck. And if you do it properly, so that it's visible to employees where it needs to be through such processes as labor management consultation, then you also help with the engagement piece for the local. So and for that matter, management's willingness to go to the local to address concerns that they might have. So, so the concerns basically within a local, how best to interact with management in relations to members' concerns that may impact political campaigns, such as fixing Phoenix. Basically, again, there's an aspect of this where how this actually directly affects the collective agreement. The primary impact on the collective agreement for Phoenix type issues lies in the pay structure, and most collective agreements where they say you're going to be paid this amount of money and you're not. This is where you are citing your collective agreement on this kind of stuff. Now, a lot of people haven't actually put grievances in on Phoenix, and this is as time goes on, this kind of undermines the ability of the union to turn around and say, this is a larger problem because you don't have the actual evidence from grievances. But there's a number of other avenues where PSAC has essentially got consultation on a lot of these issues, and that consultative framework where they're doing reports and status updates and stuff gives the kind of stats that makes the grievances a little less necessary. But that being said, there's a lot of issues that could be better addressed if the grievance process were engaged. And should that actually take place, it's important for the representatives and the members themselves to understand that when you're putting a grievance in, it's not necessarily that you're grieving a particular manager or a particular supervisor. You're grieving the employer and how the employer has implemented certain articles of the collective agreement or other policies and procedures. So, this is not personal, it's business. And essentially, the nature, the true benefit of, like the reason why grievances and stuffs exist, the grievance process, extends to, alternate dispute resolution, informal discussion for Treasury Board, and for some of the other agencies, you've got the complaint process and other avenues where these are all part and parcel of the same process to correct, inequities and, make things fair for everybody. So, again, when you're dealing with management on these kind of things, you have to make sure the manager knows this is not a personal issue. This is specifically dealing with the systemic injustice or aspects where the employer has not properly implemented policy or procedures or the collective agreement. So, regardless of the political implications, the duty of the union to represent the members of the or the collective agreement is paramount here. These are legal obligations, and if the union doesn't abide by those obligations, we're subject to litigation. And managers need to understand that this is a although this is a secondary duty, there are legal obligations and there's consequences that require the representative to take certain actions. And with respect to timelines and things like that, the collective agreement lays out a number of timeline-specific critical issues that have to be addressed. And if they're not, then this becomes problematic for not just the member, but for the union itself. And if management interferes with that whole process again, then it becomes not only the union's problem, but it also becomes the employer's problem. Ultimately, that's one of the reasons why you're trying to resolve matters at the lowest possible level, so that you've got the representative talking to the manager or the supervisor or the member himself, utilizing avenues like informal discussion to address the concerns. When you get to the point where the grievance, you have this aspect of the representative being equivalent to the hearing officer, and that's true with respect to interpreting the articles of collective agreement, because we're both coming at it at the same context. We may have context and implications specific to a unit that helps us understand the situation better and how to actually, how it should apply, and essentially, one of the important aspects of addressing some of the issues is management's right to manage. So, with rights comes responsibilities, and the exercising of rights require that they be done, in the case of management, that it's be done fairly, and in the case of the members, that it's being done responsibly. To that end, most of the collective agreement articles, have conditions that have to be met in order for the right to be actually claimed. But in the general context, the most effective way that many locals have found is to treat management with respect, and to negotiate in good faith, and that means basically being upfront to the degree you can, and sharing the information that is things again through the lowest level. We also can't forget the right of the union to inform its members, because essentially this is most evident in a strike situation, where we also have the right to inform the public of why we might be on strike, which is what picket lines are all about. There's also there's aspects of union rights that are within the charter, the right to assemble, this sort of thing. And it's within the interest a lot of the time of management to allow the union to function in an efficient manner, in an effective manner, so that essentially some of the problems can be nipped in the bud and not turn into grievances costly to the employer and even more costly often to the employee. So again, it's not necessarily a question of trying to keep the union down. It doesn't necessarily help an employer who wants to actually efficiently or effectively implement its program. It's you want to utilize the resources that are available, and members need to know that the union has resources that are available to them if situations develop that, or if people have concerns, and it's you have a voice. You may not necessarily be as an employee, you may not be willing to necessarily speak to an issue directly, but it's good to utilize the resources and bring the issue forward in the most productive way. So you may not necessarily, as an employee, have or feel comfortable bringing a particular issue up to your supervisor, although that's encouraged. But understand too that you can bring issues up through the union, through your representative, whether it be a health and safety issue or labor relations. And it's important to remember that the vested interest of the union is, like an effective union, is to ensure that the integrity of what you're actually bringing forward has merit, and the measure really of the extent is the degree to which that you've done your homework, and you've, like as a representative, that you've done your homework, and you're not just bringing a concern that's frivolous. You're bringing a concern that actually matters to the individual or to a larger group and has implications. Now, it's important to that the management understand the balancing act that we have. Again, this right to inform also comes with an aspect of confidentiality and a right not to inform, and that includes where is this, who is complaining about this. As a representative, if somebody's told you something of this something that's sensitive, or somebody's brought an issue forward to you in confidence, then you can't expose them, and members need to feel comfortable that that is going to be respected. And so if management doesn't respect that, again, there are grievance processes, a policy grievance within the case of Treasury Board to address that kind of thing if management consistently goes after that, or for that matter, labor relations complaints through the Labor Relations Act that applies. It's important that we're aware of what our rights are as employers and employees and unions, and the responsibilities that we have, because at the end of the day, we're all kind of in this for the same sort of thing, which is essentially making the workplace as productive, as efficient, as effective as possible, so that you've got a challenging and rewarding job as an employee that helps pay the bills and keep a roof over your head, and as an employer, that you have a sustainable business. I want to thank everybody who came out to the lunchtime workshop and orientation session, and also to you for watching this video. Thanks again, and tune in next time for our workshop number 2 for this series. Thanks again.